Good morning, everybody. And we are getting ready for the continued evidentiary hearing with Adam Lally and Michael Proctor. Supposed to start in about, 7 minutes. I see the courtroom feed. I already see it's up. So we will have it going. I'll just show you what's going on there right now if you want to take a look. You may remember or recall that courtroom. Should be very familiar to you. And maybe we may even get a guest appearance from the fan. So if we're lucky, we may get that. But in the meantime, we should be very familiar with this courtroom. So nothing's going on there right now, but I do want to make a few quick announcements and mentions. The first thing is that actually I have something today that I'm going to be starting at 9 o'clock, but this is something private for my own practice, and I'm not going to have to stop the feed. So don't you worry. But in case you see me disappear off the screen, it's because I'm in the middle of something called a facilitation. If you know what that is, great. It's something on one of my cases, and it starts at 9. It's all on the phone. So if I happen to step away, or if you see me hit the mute because I have to answer a phone call, it's because I'm in the middle of this facilitation. So don't worry. We are going to be completely focused on the facilitation, the benefit of my client when I'm on the phone. And when I'm not on the phone, I'll be completely focused on what's going on in the court. But just in case you do see me drop off the screen, or if I hit the mute button and you see me on my phone talking, then it's just because I'm in the middle of this facilitation, which is also starting at 9 a.m. today. So just wanted to put that out there so you guys know what's going to go on with me. Also, if you are a Brother Counsel Sidebar member, we are going to be having another Q&A hopefully soon. So you should be submitting your questions, if you have any, to the email that I posted. It's brothercounsel99@gmail.com. So send that in, and we will get that all queued up and ready for the members-only Q&A. And remember, the Q&A is on any topic at all. Could be legal, could be otherwise. So just wanted to remind you all of that. Now, there was a motion that was filed apparently last minute from Adam Lally, about Adam Lally, I should say. Maybe some of you have seen the motion already. And basically, Adam Lally does not want to continue on the stand, as you can imagine, because this is a very fierce attorney, and she's going to have a good time with him, probably, or continue having a good time with him, talking about his list of discovery items. And he just crosses them off the list. And also, right before trial, he decides to have a meeting with the detectives just right before trial, just to make sure that he's got everything. Because why would you want to do that before trial? Like many, many months before trial, just to make sure that the other side has all the discovery. Why would you want to do that? Well, he has since changed his practice. So he's changed his practice now, and now his practice is actually to meet with the cop and make sure that the detective or the trooper turns over the entire file, so he can make sure that he complies with his Rule 14 and Brady obligations. Yeah, so he wants to be off the stand. That's what they're talking about. That's what this motion is about. The court should suspend Lally's testimony unless and until the defense makes a preliminary showing as to the 3 required prongs required for dismissal. I doubt the judge is going to allow this. Egregious government misconduct, prejudice to the defendant's right to a fair trial, and is showing that dismissal is the only remedy for the prejudice. So I don't think that this last minute motion is going to get granted. And I don't think it should be granted. He's on the stand. We're trying to find out all this stuff. How are we supposed to have a preliminary showing of it without his testimony? We need to have his testimony. So I could go through the entire motion, but it looks like hopefully court's going to start soon. I'm keeping an eye on the feed. People are just walking around now talking. And let's say hello to some of my wonderful people who joined us today. And I may mess up your name. That's just fair game. Okay. If you don't have like a regular name like, Lisa or Nick, I may mess this up. So let's see. Licit 4081. Exciting. This is very exciting. Got Adam Lally and Proctor supposed to be on the stand today. We'll see if there's any last minute changes with that. Mila Rivera, 2686. And I don't know if your names are coming up the right way or not. I know that YouTube's been having some issues with that, but good morning, good peeps. And my brother from another mother. Can't wait to see what happens today. Or is Proctor still on vacation? Well, from what I hear I remember from last hearing, the attorney told the judge that at this hearing, Proctor will be there. So unless something changed last minute, who knows, we should be seeing Michael Proctor, former trooper Michael Proctor, who yesterday had some sort of administrative hearing. Did anybody know what happened with that administrative hearing regarding getting his job back? Nicole, this is Must See TV. Good morning, BC. Good morning to you. Good morning, Bonnie Castillo, 862. Good morning to you. Thank you for our wonderful mod, Blurry Lights. We are live. We are live. Thank you for being here. Nicola Cox, hi all. Jessica Lee, looks like your name is back to normal. Good morning to you. Simi Sharp, 9911. Good morning, Brother Counsel, and good morning to you. So let me just show you what's going on in court in case you think you're missing anything. You're not. That's what we see in court. So I can have that up while we're talking. Donna Bonneville, 4058. Good morning, brother. Wildcats, 32. Will the judge make Lally testify again? He doesn't want to. LOL. That's right. That's what the motion's all about. And I think the judge is going to make him continue testifying. I think that's the whole point, right? The whole point of this evidentiary hearing is to hear what was going on and to determine whether there was some egregious government misconduct. Katie Cat, good morning, Brother Counsel and chat. Made it just in time. Rhodes Girl, good morning to you. Phoebe Purvis, is this really going to happen? All right, well, I'm getting my first phone call on the facilitation, so I'm dropping out for
Ready? Let's go. Let's do this.
Our office.
Yeah, that Lisa's training at 9.
Okay.
Mike, did you see those two cases? Did Jen tell you about the two cases? Okay.
Yeah, thank you. I don't know yet. I was about to find out. Listen to what about to happen. Hey, are you all set?
Yeah.
Yeah. You have to go into Zoom, right? So it's about 2 minutes. Yeah, I'm ready to. I'm sorry, what? Do I? Do I?
Welcome to Zoom for Government. Enter your meeting ID followed by pound.
Aaron Wayne and Mr. O'Driscoll. We see either one of those? We're good to go on this.
Enter your participant ID followed by pound. Otherwise, press. You are in the meeting now. There are 6 participants in the meeting. You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting. You are muted. You can mute or unmute yourself by pressing *6.
And I'm not introducing any of the charts today, so we can go over them. Yep. You're probably going to doesn't have a lot of time to put things on. We try to go according to your emails and all the bait stamps, so everybody could find it. So the bottom line is, it's a good thing you bait stamp stuff. Oh, we would have been like, this wouldn't have happened for another 2 years. Yes. Yeah. Mm-hmm. I actually offered, just so you guys know, I offered to buy you a bait stamp machine and stuff in like 2000 and 3. Yeah, saying like, this is crazy. You guys can't figure this
What
out.
did she say?
Like,
Oh, Sue's on her way up?
Bates.
Oh, yeah, that's fine. No, she told me she was trying to get here when she was going to get here.
which it should have been. Everything.
I just assumed to stay. I can look at emails.
Yeah.
If he comes out before she comes out.
Yeah. What is
CBS.
Myles?
CBS. I'm calling it from CBS.
Thank you.
No. I'm sorry?
Doug.
Are you here for Tracy?
We're here for everyone. Limo and I help people save hundreds by customizing car insurance with Liberty Mutual.
We ordered a limo, not a limo.
Oh, yeah. We do that too.
The limo?
At your service. Only pay for what you need.
Liberty, 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 liberty.
Lonnie Anderson has passed away. The star died on Sunday at the age of 79, just days before her 80th birthday on August 5th. Her longtime publicist confirmed her passing to NBC News, revealing that she passed away at a hospital in Los Angeles. Anderson's family also issued a statement that reads, quote, "We are heartbroken to announce the passing of our dear wife, mother, and grandmother." She was famous for her role as Jennifer Marlowe on the show WKRP in Cincinnati, for which she earned 3 Golden Globe nominations and 2 Emmy Award nominations. She was also known for her role in Stroker Ace, which she starred in opposite Burt Reynolds. The pair ended up getting married in 1988 and divorced in 1994. They were parents to son Quentin. Prior to being married to Reynolds, she was married to Bruce Hasselberg from 1964 until 1966. The pair shared daughter Deirdre. She was also married to Ross Bickel from 1974 until 1981. She wed Bob Flick in 2008.
As any actor will probably not tell you, but I'll tell you, it's very easy to just be swept up in what you're doing, you know. In wrestling, you are giving your own performance, but you're also very conscious of the other performer and keeping them safe and staying on track with them. So I think it just makes me even more aware when I'm in a scene with somebody else that what am I doing to support the overall goal here.
Now, cover me.
As any actor will probably not tell you, but I'll tell you, it's very easy to just be swept up in what you're doing. You know, it's the old joke of like, you ask someone, what is Hamlet about? And they play the guard in Hamlet. And they go, well, it's about a guard who knows this guy named Hamlet.
Hey, answer me. Stand and unfold yourself.
Being a sporting actor, you just want to be hyper aware, and that's been sharpened with pro wrestling.
Which professional wrestler would have been a great cop in The Naked Gun and why?
Somebody like Chris Jericho, he's a funny guy, and he's the kind who could insert himself and probably play like a goofy, cocky police officer. Yeah.
Finding what you need, okay?
Mm-hmm.
Come with me.
Get what you need from someone who gets it.
Of course, it's been hot this summer, and so we want to keep our dogs safe. So we're going to learn more about that with our friends here from the Animal Rescue League, Mike DeFina and Courtney. But we are also going to meet little Remy.
We got to meet her earlier. Sorry, we cheated a little bit. But who is she? Tell the audience who exactly Remy is. What should they know about her?
Well, she's adorable, as you can see, of course, first and foremost. So she's a transport pup from the South. She's been with the Animal Rescue League of Boston for about 3 weeks now, and she's ready to find her new home. She's an absolute love bug, loves everybody, and it's just looking for love. She's a fun young adult dog, and affection. That's what she's all about.
Hand when you meet her.
Yeah. She really just wants to snuggle in and give love and get love and just have fun.
And Mike, you were saying because she's over 50 pounds, there's a little bit of incentive.
Yeah, so we're really excited for the start of Clear the Shelters. It's always a great time for the Animal Rescue League of Boston.
Okay, what in the world is going on here? Exactly. Okay, I just leave for a little bit, and then what in the world is going on? I don't know what they did, but now we're back. I apologize for that. Of course, I had to take that phone call, but now we are back on the record. So here we go. I don't know what in the world they went to. This was NBC Boston, but I'm going to have it up right now. So here we go. Apologize for that. Of course, that's got to happen, you know.
We can get some movement this afternoon. I think I told everybody last time, out through the 11th. So I'm back the 12th. I'll see you the 12th. I'll see you the 13th. Whatever is convenient for everybody to get back together. I think.
Judge, I appreciate that 100%. My concern is if we know that we're running up against that clock that runs out on the 18th of August, is there a way that the government can now, or the Commonwealth can now ask the government to extend that order again? I don't want to be in a situation where you finally make a decision.
I think the Commonwealth understands that. So.
Yes.
And I invited you the last time to seek to intervene or to do whatever you needed to do to communicate your concerns to the feds.
I understand that, and that's what I did, Judge. I had a conversation with the U.S. Attorney's Office, had a conversation with their attorney, and the plan was if we did not hear back in a way that was reasonable to us, both myself and Attorney Sullivan planned to file a motion on Wednesday to intervene.
Okay, great.
That was what we were planning on doing. So that's before we knew that they weren't going to have a meeting until 4 o'clock on Tuesday, Judge.
Yeah. All right. So do you want to set a date? Do you want to say the 12th?
I think the 12th at 2 o'clock, just from my reading of the emails that was going around yesterday, seemed to be the best.
I think that's what Ms. Irwin said.
Sure. Yes.
Okay. So we'll put, let me just see. We will put.
Except for Mr. Wester, I do want to say, who will still be on vacation.
Right.
And this
We
is
will put
NBC
King,
Boston, by the way.
De Los Santos, Johnson, and Chanchillo, and I think also Walsh.
Yes, please.
On for 2 o'clock on the 12th on the issue relating to the federal Proctor discovery.
Yes, Your Honor.
Thank you,
Okay.
Honor.
And is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure that the Commonwealth will alert folks to whether progress has been made. Everybody needs to be on the same page ultimately for the hearing on the 12th, and you're going to have to act quickly. The Commonwealth may have to act very quickly depending on what happens.
And I've been doing that.
Yeah. Okay. Thank you.
Thank you.
Thank you, Your Honor.
All right. Now, with respect to the King matter, we're just dealing with the issue of the late disclosure. And
May I be heard, Your Honor?
Sure.
At the close of the last hearing, you asked the defendant to provide the court with which documents were either exculpatory or would inhibit the defendant's right to a fair trial, would be prejudicial to him. I have not heard of one document since these have been provided in April and May. And to that end, I'd ask the court to order that right now. I think that This has gone on. This is now the second day of a hearing, and the Commonwealth is unaware of which document or which documents are prejudicial to the defendant and will prevent him from having a fair trial.
We had two things I was looking for. I was looking for that, and I was also looking for some sort of a agreement of the parties, if it was worked out, to identify which of the documents were newly disclosed, which were partially disclosed previously and fully disclosed more recently. And then there was the prejudice analysis as to the new documents.
Correct.
So there was sort of a two-phased process. I don't know whether either one of those phases happened, whether the parties met and tried to work out an agreed list as to what was new or what was not new.
I endeavored to work with ADA Hickman to ensure Your Honor had a complete list as diligently and as best as we could of what documents were previously produced, and that was provided to Your Honor. I believe was sitting on your desk as Monday morning. It was the third exhibit that the Commonwealth provided. We did confer on Friday afternoon. It was represented to me that counsel would be providing us a disagreed list or a number of other lists to show the court what they disagreed with.
I got a pile of documents.
And we got that as well.
This is the pile that I got, I think, from Mr. Piccio's office. I don't know if included in there is the chart that you folks worked out that you say was on my desk. I'm not sure I know what you're referring to in terms of a list that was new or not new, but maybe it is in the stack.
It's a table. It's the third. If you look in the manila folder that's underneath that, there, in a rubber band, it's in your hand right now.
Oh, in here. Okay. This one.
That, yes. The third doc.
Okay.
That is what I prepared with the assistance of ADA Hickman.
Okay.
Which specifically describes what, if anything, is minorly different. That was provided to counsel on Thursday last week. We met we got a teleconference on Friday, and counsel was working on their own lists.
Okay.
So to answer your question, no, there was no agreements as of now. We endeavored to meet earlier and understand from my pleading what counsel disagreed with, but that was not reached. We provided you, the Commonwealth has provided you as best we can what has been previously provided.
Okay.
If there's any subtle differences, we can supplement that at a later date, but at this point, I know ADA Hickman has worked very hard to go through the material.
Attorney Scapicchio?
Thank you, Your Honor. So we've provided 3 charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth's opposition in disputed documents from pages 7 and 8 of their motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you have 2 dueling charts, huh? So you have the Commonwealth's chart and your chart.
Yes.
This is exactly what I didn't want to have happen.
I understand, Judge.
So why didn't you get together and work, figure
Well,
out
Judge,
a...
I tried you.
Well, I think we both tried. I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I've spent my time doing. So when we spoke on Friday.
Do I have a list of the items which are new or which you claim to be new, and that I can then cross-reference against the Commonwealth's list, which you say are prejudicial or are exculpatory and you're behind the 8 ball because of the late disclosure, notwithstanding the continuance.
Yes, Your Honor.
Okay, where will I find that?
So where will you find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
That hasn't been completed yet, Judge.
Okay.
I just got to the point where I was able to send a list to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion, and here's what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had between now and the last hearing.
All right. So you need more time to get other stuff
I
done.
do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. Because I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say, this is where we are and this is where we stand. But if we don't have everything and we're going to come back in a week and they're going to hand me something else in the morning of the hearing and say, this is,
Well,
now this
as
is
an initial crack, I wanted a list of what was new and what was prejudicial in the 2 notices as of when the motion to dismiss was filed.
Yes.
That's what I think we were shooting for. We
And that-
understood that some new stuff had been produced after that.
Yes.
And I don't know what the explanation is for that, but in any event, we're looking at what was filed as of the time the motion to, what was new as of the time the motion to dismiss was filed.
So Judge, what I did with the new information is I put it in chart 2 as just a description of it. I cross-referenced it to a bait stamp number if we had it, and I put it in a discovery category, which is I thought what the court asked me to do. So some of it has to do with jail calls, some of it has to do with social media, some of it has to do with search warrants. I've categorized it in a way that I think that I was hoping it would help the court understand.
Can we make a record here?
Isn't that what we're doing?
You were referring to lots of stuff which is not in the record.
Correct.
Right? We admitted in the last hearing exactly 1 document.
Yes.
Right? If you are referring to particular charts, let's be clear about what they are. Let's mark them as an exhibit, and then we'll discuss what we need to do. You can explain what those documents are to me without a witness. I think that's sufficient, and then we'll decide whether we're going to proceed with the hearing on an evidentiary basis today or not.
Thank you.
Oh, I'm sorry.
All right, so I've been handed 3 charts. Chart 1, chart 2, and chart 3. You're moving their admission?
Yes, Your Honor.
Okay, any objection, at least for the record here?
No objection.
Okay, so these will be marked as, unfortunately, exhibits 2, 3, and 4, because we already have an exhibit 1.
And may I admit the Commonwealth's exhibit,
Um,
the chart.
This is the Commonwealth exhibit.
Yes.
Any problem with this?
No, Your Honor.
Okay, so this
They've
will be
heard.
exhibit 5.
Thank you, Your Honor.
Thank you.
So this is just taking care of all the matters before they actually get to the evidentiary hearing. And again, I apologize for what happened earlier. I have no idea what happened. I had the stream and then I stepped away to take this phone call and then everything all just broke loose. So now we got the stream back. So
All right, how do I deal with these charts? How do I read them? They look like you're talking past each other to some extent, that they're not, that so if I look on exhibit 2,
Oh, God.
which is the defense chart number 1, discovery address in Commonwealth opposition to our motion to dismiss. Item 1, copy of search warrant affidavit for T-Mobile cell phone, draft affidavit. What does this tell me?
So what that's meant to tell you, Judge, is that the Commonwealth is, in their pleadings, are indicating that we actually got the search warrants. We didn't get the search warrants.
No, hold on. Not argument, just what does this show? Document description is received by King.
Right.
What is that? What's in that column?
So that column is what we actually received as opposed to what the Commonwealth is claiming they gave us. And it's categorized. So the Commonwealth is claiming, so for the first 2, Judge, if I can just show you, for the first 2, the Commonwealth is claiming that they already provided those search warrants to us. They haven't provided the search warrants to us, Judge. In fact, what they provided to us was.
No. Just slow down. I want to understand what Exhibit 2 shows?
So Exhibit 2 takes the Commonwealth's opposition.
What's in column 1?
Column 1 is the description that was received by us.
You're
from
quoting
Commonwealth.
something from what?
Discovery notices, Judge.
Draft affidavit for search warrant 21 SW. I'm sorry, you're quoting what?
We're quoting what the Commonwealth named these documents in their opposition, Judge. That's what the Commonwealth named these documents, to try to convince the court that we already had them. There's search warrant stuff down there. The two.
Okay, and you don't have any Bates numbers here, so I can't go and find these things, right?
Right, because the Commonwealth didn't have the Bates stamps in the ones that we did. So if you look down to the second column, we do have Bates stamps. There were some things that were given.
Second column?
I mean, second part of the chart. We were able to provide Bates stamps.
Second chart? Or
No, just where it says notice 4925.
All right, so how do I compare what you have to what the Commonwealth has provided me? I need you to be on the same page. I need you to go through every single document that was produced that you base your motion to dismiss on. Every single one. You have to address every single one, okay? And you have to make a chart saying this was produced in Discovery Packet 1. This was never produced before, okay? I don't need argument associated with it. I just need to know the universe of the problem. I need to get my arms around the scope of the problem. And then I need to know, with respect to anything that's new or substantially new or partially new, why you're prejudiced by the late disclosure of that additional information.
Understood, Judge.
So I don't have that here, right?
I thought you did. I understand now you don't follow it the way that I followed it.
Well, I don't understand it. So I need you to explain to me why you think I do have that, if I do.
Well, I think you have part of it, Judge. I don't think you have all of it.
All right. So I need all of it.
Okay.
Okay. So I understand the scope of the problem. And then I can analyze the question of prejudice after you've analyzed the question of prejudice.
Yes, Judge.
So how are we going to do this?
We're here at 9:24. I'd be happy to meet with the parties downstairs for the next 3 hours.
I think that would be a much more productive use of time than putting Mr. Lally back on the stand.
Uh-oh.
Or anybody else. Because there are real constraints on the court's ability to provide a remedy beyond the remedy that has already been provided, absent real showing of meaningful prejudice. And so I need to understand where that prejudice is coming from. And so you're welcome to spend the next 3 hours doing that.
Sure, Your Honor.
Okay. I know everybody's here. I know we have witnesses here. I'm sorry about that, but
what do you know?
I think we need to do this in a logical order.
Thank you, Your Honor.
Yeah, he does.
I have a hearing at noon, from noon to 1, where I have to finish an evidentiary hearing in another 2 co-defendant case. That'll take me from noon to 1 o'clock. I'm happy to see you at 2 if you're able to make substantive progress between now and then, or I'm happy to just see you on the 12th.
I don't
But
know
the
where-
12th would not be for evidence. It would be for an explanation of the analysis that you've done on all the various documents that were apparently produced late.
I don't know where we'll get it. I mean, we could let the clerks know if we could.
I'm happy to report back at 2, Judge, if that's what you want us to do.
Yeah. I would like to release the witnesses.
Yeah, I think you should release the witnesses. I think and I think, frankly, I should see you on the 12th, because if you're not done by 12 or whenever today, we're going to be together on the 12th. It's the soonest I can see you after today in any event, and it'll allow you to do the prejudice analysis, because that's the first part of it. That's great. Everybody's on the same page as to what's new. And then I need to hear from defense counsel document by document as to why it's prejudicial that this was lately disclosed.
Yes, Your Honor.
Your Honor, if I may, I believe we have one outstanding issue that was brought to the court's attention, and I believe Attorney Moynihan is here.
We're none.
We had the order of Judge Doolin of June 17th relative to Mr. Proctor's personal phone, and Attorney Moynihan has filed a motion on our last date relative to that order, and I wondered if we could address that today. It's the one outstanding issue that we have on Judge Doolin's June 17th ruling relative to Mr. Proctor's personal phone, Your Honor.
Judge, I didn't know we were addressing that today.
My understanding on the last date, Your Honor, is we put it down for noon because Attorney Moynihan would be here, and today would be the day that we'd be addressing this issue relative to Judge Doolin's order. I believe I asked the court on our last date whether or not this needed to go back to Judge Doolin, and Your Honor indicated that you had read the order and felt that you could make a decision.
Frankly, Your Honor, I didn't notice we were addressing that today.
Would you like to be heard on the 12th also?
I would need to check, but if I could be available on the 12th, but that would be a better day than today.
Okay.
You want to check? You have your calendar?
Sorry?
You have your calendar?
I'd have to just call my office.
Okay. Let's put it on for the 12th. Call your office. If for some reason you're unavailable, let me know. I'll get back on the bench and we'll set another time.
Is that 2 o'clock, Your Honor?
It would be 2 o'clock, yes. I have the papers here. I didn't read them for this hearing, but I will take a look at them now. So if you decide you want to be heard today, I'll hear you on it.
I prefer the 12th. I can let the clerk know if I'm available to it. I believe I can be available.
Okay. All right. So if you can be available, we'll hear you on the 12th. Otherwise, let the clerk know and I'll hear you now. Okay? Okay. Anything else we can do today? Thank you.
Thank you.
I'm glad we just wasted the whole morning. That was silly.
What? I get it. All right. Are we going downstairs to your office? Are we doing this here?
Is that Turtle Boy right there?
Great. Thank you.
Nice job.
It is. Okay, so basically, we were supposed to have a continuation of the hearing today. And the judge, there were a number of documents that were turned over. And then the judge says, okay, well, you know the way this works. The way this works is that not just that there's late disclosures. You know, that you're right, they did something wrong. They didn't disclose it. But you have to show the court that that is prejudicial to your case, the late disclosure. And it's such a prejudice that the only remedy is dismissal. So what the judge says he can't figure out, you know, after all of these, after I just saw this comments, I got to put it up there, Brother Turtle. Turtle Boy, Brother Turtle. Anyway, so the apparently Rosemary gave him some sort of chart which we weren't able to see, and in that chart she was identifying different documents which were not disclosed, and therefore there was some prejudice, and he wanted really them to have a organized chart together. He wanted them to meet and confer and figure this all out together. And apparently that didn't happen. So now she's got two charts, one from the prosecutor, one from the defense, saying which documents were turned over, which documents weren't turned over. And then once you know which documents were not turned over, so then what does that mean in terms of prejudice? You know, is there prejudice? Make the argument for prejudice. And she wasn't able to do that today. So the judge says, okay, well then I guess we shouldn't have an evidentiary hearing. Now, if those were all the documents that were turned over, okay, that's one thing. But there's also the fact of why they weren't turned over. And is there any misconduct there? Why not if the witnesses are there already? And I think the defense could have made this argument. I don't know why she didn't. Now, Your Honor, I understand that you want me to point out certain documents that show that there's prejudice and why I didn't get those documents. But there's also other questions here. And the best way to address those questions and get answers is to have an evidentiary hearing. The witnesses are here. They're ready. Lally's here. Proctor's here. If you want to put Lally over, you want to sit on that issue that was filed, okay. But Proctor's here. Let's get started with Proctor. Let's figure out why these documents weren't turned over. And if it was done for a malicious or nefarious purpose, now we're talking about misconduct. So why not just have the evidentiary hearing? They're here anyway. And you want us to take another 3 hours. We're going to adjourn for another few weeks anyway. So we have to go through these documents anyway. But there's still other issues, right? It's not just limited to what documents were turned over and whether I can make an argument for prejudice about them. It's also about why they weren't turned over. And is there misconduct? And if maybe there's more documents, or maybe there's more stuff that we don't know about if we actually get Lally and Proctor on the stand. So I don't know why that wasn't done. But now what's going to happen is that we just had a morning. Everyone's there. It's all just a wasted morning. Everyone was there ready to go. We had this evidentiary hearing set up. And now, what is it? They're going to come back at maybe 2 p.m. And the witnesses are done. I mean, the witnesses are not coming. There's going to be no evidentiary hearing. So the best that we can hope for is that they're going to get together now in the basement for 3 hours and go through the documents and figure out what they received, what they didn't receive, make one working list so that they can show the judge, okay, these are the documents we did receive. These are the documents we did not receive. And then we can start making an argument for prejudice. That's what they're going to be doing the next 3 hours. They may come back at 2 p.m. I'm not sure if that was clear or not. Other than that, it looks like they're going to be coming back August 12th to have the evidentiary hearing, or the continuation of the evidentiary hearing, or continuation of the argument. So this was, just a big waste of time for everybody, and unfortunate because everyone was there. Everybody rearranged their schedules to do this. So unfortunately, that's all we have today. That's it. So what a waste. But there is this motion that was filed that I still should get through. But I don't think I'm going to read it now for everybody. So, all right. Well, anyway, again, I apologize about what happened earlier. I have no idea what happened there. I stepped away from my desk and then everything all just breaks loose. I stepped away. I had the feed on. Everything was great. I just had to take this phone call, which I actually just took again. And then I told the person I'll call him back, facilitator. So I got to call him back. But yeah, so a waste. I think that we could have had the evidentiary hearing. I don't think it would have hurt. The witnesses are here ready to testify. It's not like they won't add information that we don't know. But okay, that's what the judge decided. So thank you all for joining, and we'll see you at the next live stream, I guess. Take care.